Oh, so, okay, good morning. It is May 3rd. 2.1. And this is Senate Health and Welfare. We're looking at two amendments this morning, two bills. One, the first one with Ledge Council is H 121. And we're only going to spend about a half an hour on that. So, thank you, John. And I know you sent us a tome.
Yes, I'll explain why.
Yeah, please. Yeah.
Okay, so John Gray, Office of Legislative Counsel. Good morning, happy Friday. Screen share. Okay, so the draft that you're gonna see here is a good bit larger than what you saw last time. That is not a reflection of huge additions. It's that I needed to pull in the entirety of the definitions section to make some changes to the exemptions section. And because that results in some renumbering, I wanted to make sure that everything is captured correctly. So the highlighted sections, which I will walk through, are the actual changes here, but the ballooning of the amendment does not reflect huge changes. So I think it's probably easier for me actually to jump to the exemptions and then come back to the definitions. So that's what I will do, because they're not going to make any sense in the absence of the exemptions. So we can turn to the second instance of amendment, which is on page 15, very bottom of page 15. So what's being done here, we're talking about the same subdivision 2 exemption that we've been talking about all this time. What we had yesterday was an exemption for HIPAA entities, and what it said is an institution in its capacity as a covered entity or business associate. We heard from folks in the industry that it might be hard to make these determinations, that it still requires some analysis. So I have some proposed language here that I think may get at the concerns for dual capacity institutions, entities, which is what I think you guys were trying to capture, while using accepted HIPAA terminology that will be clear to folks in the industry. So that's what this is. So some background before I state the language. A HIPAA contemplates a couple of things. So we've talked about covered entities and business associates, but there's a category of covered entities called hybrid entities. And what these are, let's say you're UVM, you could be a covered entity as a whole, and every part of you would be subject to HIPAA, including the non-hospital elements of what you do. But likely you don't want to have that happen. You want to have flexibility on the non-medical parts of what you do. So you can designate under HIPAA to be a hybrid entity. And what this means is you're calling out particular components to be subject to HIPAA. You're saying that other components are not subject to HIPAA. That gives you the flexibility to have your non-healthcare related pieces dealt with outside of that scope. So a hybrid entity designates what are called healthcare components, and those are what's subject to HIPAA, and the other pieces are not. So the proposed exemption here is for covered entities that are not hybrid entities, meaning someone who is wholesale, full stop, they're subject to HIPAA as a whole. So that's someone we can say that all of what they do is meant to be subject to HIPAA, and therefore we deem that to be protected by an independent privacy regime. So that's the first part of this language on line 18. The second piece here is any healthcare component of a hybrid entity. So this is calling out just the pieces of those hybrid entities that are subject to HIPAA, but the non-healthcare components of those hybrid entities would be subject to the Data Privacy Act. So this is a way of getting at that dual capacity piece. In the UVM example, they could designate, and they are required to designate particular pieces as healthcare components if they meet particular healthcare. Essentially, they kick them in. So in the UVM example, the hospital and maybe certain research arms, this could be a choice for them, would kick into being under HIPAA as a healthcare component. That would be exempted, and then the portions that they don't designate as healthcare components would be subject to this act. The last piece is for the exemption for business associates, which is consistent with what we were talking about last time. So I think that this is a clearer place to land that captures the concern, but happy to, and I can scroll up to, I mean, what you're going to see at the definition section is just a set of things that say a hybrid entity has the same meaning as under HIPAA, healthcare component has the same meaning as under HIPAA. And that's just to say that we are using things that healthcare industry is already accustomed to. They should know the designation process. They should know about healthcare components. This isn't asking them to make a kind of analysis that they wouldn't already be making.
Wow.
Brilliant.
So
Yeah.
Good cut.
Nice job.
it's not on me. I don't. Yeah.
But you've done it. you've done it,
I like that.
yeah.
I'm gonna refuse to look behind me.
I can see,
I'll accept.
we know, that's great. Thank you, I'm looking at both John and behind you. Okay, thank you for the work on this. It's been a tough one.
So I may come back to the definition section, although I don't know that we're necessarily going to need to, but maybe at the end I can do that just so you guys have assurances that nothing else has changed, although I can assure you that I haven't, just mysteriously changed definitions. The third instance of amendment, this is on page 16. This is not something that we talked about directly, but I thought might be implied by the changes that are being made here. This is our catch-all bucket for intermingled and treated similarly data for health related. So this is an exemption for those pieces that folks would have the opportunity to treat under HIPAA and therefore have an exemption for. Based on the testimony that we heard that folks don't actually know how they would treat pieces of information in the same way that they would under HIPAA. And I knew that that was a request that had been provided to provide flexibility to the healthcare industry. Given that you're providing the entity level, the crafted entity level exemptions that you see here that we just talked about, I don't know that you still need the information that is treated in the same manner as call out in this subdivision 8. So I've removed that because I think it is now not necessary, and based on the fact that people were confused by it, doesn't seem to offer a lot of utility. So this is just tightening it up to remove that piece and returning to the original form, which is information that originates from or is intermingled so as to be indistinguishable from, and this is consistent with approaches taken in, this is what Oregon does. This is the same concept embodied in the House version. The House version does have that treated in the same manner, but I think we don't need that anymore as perspective. The fourth instance of amendment, this is to accommodate the AAAs. So this is, we're still talking about exemptions. So we're in 2417A, and we're adding a new exemption for area agencies on aging. This is specific. There happens to be a Vermont underlying definition. I think I would have known this if I was more commonly in this committee. But you guys do have in Title 33 a definition of area agencies on aging. And so we can just call these out directly. We don't have to come up with a more broad catch-all that might accidentally pull in a bunch of nonprofits that we don't intend to capture. So this is a entity level exemption that is specific to the area agencies on aging, and I will pause there.
Yeah, I'm curious about this one and why this one is necessary. We didn't get testimony from them directly. And I am actually concerned because they serve pretty vulnerable adults who are not tech savvy and are just the kind of people who might be taken advantage of. Not to say that our AAAs are doing that, but I'm concerned that there's a possibility
They would.
that it could be in some cases, if they're not covered by this data privacy law, a thing that these agencies could do to take advantage of not having this protection.
So that's a question. We did have Mary Hayden in, and she has sent us a lot of information. I think, I'm not sure if Kiki has posted it or not, but we did have that written testimony. So this is a choice that we make. I do think about their vulnerability as an agency where they're dealing with people who, as you know, said, have illnesses, and need some protection. Goes both sides.
Yeah, I just, and also thinking about the future landscape, as more and more for-profits are coming in and sort of getting into these markets, I worry about that as well.
Yeah, I know, I thought about that.
Is it helpful for me to find the underlying definition?
Yeah, let's look at that. I was gonna see it. That's in Title 33, I think.
Yeah. Yes.
I mean, this is something that a report back could help with. Here it is.
Yep. area agency on aging, an organization designated by the state. So it is, the state has to make a determination to develop and implement comprehensive coordinated system of services, supports, protections for older Vermonters, family caregivers. I think the designated by the state pieces maybe some assurance. And do take the point that you are, the choice you're making is if you accept that these are good faith actors. I have no position on that, but you are correct in that they will not be, our understanding is subject to HIPAA and they wouldn't be subject to this act. So it's basically accepting that they will operate as they say they will.
Well. Swallow wrong. If it says, family caregivers, as the implication, health caregivers, as well as other services or kinship caregivers, does that imply HIPAA? And so this, does it become a hybrid organization, I guess?
So I don't know the answer to that, but
Yeah.
based on the fact that those folks did not feel they were receiving the HIPAA exemption, I'm gonna guess they have a better gauge as to if they meet the conditions. And they would be, obviously, given the move toward the entity level exemptions for HIPAA, they would be happy to receive that exemption. So I'm gonna assume, no, they're not.
Choices for care, it's under global.
That's a good question. Is designated by the state mean that it is a nonprofit or could it be a for-profit?
I don't.
There's nothing here to say that it couldn't be for profit, but I don't know what the designation process is. This
Yeah.
certainly beyond my scope.
Yeah, I'm feeling queasy about this one.
I also just wonder how many other nonprofits will come in and be like, well, you did it for the AAAs, why not do it for the X, Ys, and Zs? I mean, are the home health agencies and the designated agencies, all of them are covered by HIPAA, right? So that's why they're not coming in and asking us
They could
for
be considered
exemptions.
hybrid organizations.
Yeah,
So let's do this. I don't know, what are you thinking? To Senator Weeks, you have a thought on this one?
Yeah, so I frankly, don't understand why we wouldn't want to protect the agencies on aging. With
Exemption?
H 121. Not with an exemption, but to ensure that they're covered.
this exempts them
This
from the
exempts
data
them.
privacy
Yeah,
law.
this is
Okay,
exemption.
right.
Yeah.
I understand. So
Yes,
they need
Yeah.
protection.
Well, what the AAAs are saying they want to be exempted because they don't want to have to do all the things that would be required if they're covered by this law. So they just don't want to have to comply with the data privacy law. They're not covered by HIPAA, so they wouldn't get the HIPAA exemption that we just discussed. So they're asking that we give them a special exemption because they don't want to have to do the.
and honestly, there could be some hybrid, they could be hybrid, it depends on what level of care services are being offered. So I'm moving back. I was there, I was feeling that the volunteers that are going in should be exempt. However, I think let's leave this to the analysis that is going to happen, the reporting process.
And I'll just,
Yeah,
I think you guys have made your decision, but to state their position is that
yeah,
the compliance costs are gonna stop these providers of low-cost services or free services to not be in a position to offer those anymore. I mean, at least that's the claim, is that this may debilitate them if they have to incur compliance costs under this act. I don't know if that's the case, but that's their claim.
well, we'll find out. I mean, and honestly, the group that's working on it, by 2025, we may have additional information that will help us make decisions, maybe better decisions, so.
Yeah.
Okay.
Yeah, I agree. Let's not call out one organization at this time.
With that, I think we can jump down to fifth instance of amendment remains the same as what we discussed yesterday, so I don't need to dive into
Page
that.
17. Yeah, page 17.
Yep, that remains the same, and so we can jump on to page 19, bottom of page 19 of the highlighted language. This is not a substantive change. This is what we agreed to yesterday. It looks dramatically different in form because I changed the presentation based on what happened. This is the amendment that's just clarifying that those mental health facilities or reproductive or sexual health facilities in the prohibition on geofencing are included in the category of any healthcare facility. The change that's happened from yesterday and that you guys agreed to was that we reinserted that language about for purposes of identifying, collecting, tracking. So just to
Oh, we
say it
did.
again, I think that was our understanding is that there actually is permissible uses of
Yes,
geofencing that
yes,
like
there-
hospitals
yes,
themselves may
yes,
do this to
yes.
establish.
Protect people. I don't remember that.
Yes, we
Yeah.
did.
It may have been like
It's
different.
okay, I know there's a lot, there's a
Yeah,
lot.
It's a confusing conversation.
The
Did we make that
We
decision?
did,
The
yeah.
specific language I think that was used at that time was nefarious purposes.
Yes.
That's what this
Right.
is. So we've reinserted the call out to quote unquote nefarious purposes.
Wait,
The reason you don't see it here is because that's in the underlying language. So
Okay.
the sole change that's being made to this section is a cleanup change to call out that mental health facilities and reproductive or sexual health facilities are included in healthcare facilities. But
Okay.
otherwise, what we received from Senate Economic Development remains the same. It's purely cleanup.
so what, can you read to me the language that, the things that are allowed for geofencing then? Or,
I mean, we don't call out what is allowed, but what is, I can tell you exactly what's prohibited. And it is a big bucket of things, or at least the concepts that are captured are quite, big. I need to go to page 50. Yes, so no person shall use a geofence to establish a virtual boundary that is within 1,850 feet of any healthcare facility, including any mental health facility or reproductive or sexual health facility, for the purpose of identifying, tracking, collecting data from, or sending any notification to a consumer regarding the consumer's consumer health data. So collecting data from any kind of information they get from that person constitute collection, identifying them. So I think you have a pretty safe call out of purposes here. This is meant to be a broad prohibition, but it is saying the for purposes of is telling you what kinds of geofencing are prohibited. So if someone is using a geofence for those purposes, that's what's prohibited is the geofencing itself. They
what
can't.
about surveillance? Would that be considered, under
That
identifying?
it doesn't have to meet this standard. It just depends on the form that the surveillance takes. What this prohibition is of establishing virtual boundaries for those purposes. So if someone's just got a pair of binoculars and they're, looking out, I mean, this isn't probably the hypothetical that you're talking about, but there's kinds of surveillance that can still be undertaken. This is a specific prohibition for establishing virtual boundaries that check if someone's coming in, collecting data from them, like.
I know, it's tough, isn't it? It's very discreet. How do you get after it?
Just not,
I think
I'm
that-
just not convinced that there are like good reasons to do geofencing.
So Senator Gulick, you want to?
Not
Well,
convinced that's a
we
good
heard
reason.
from Planned Parenthood yesterday that they act,
Please.
thank you. That they do use a form of geofencing to actually protect the patients who are within their care, and it's really important for them to have.
I must not have been in the room for that.
Yeah, I don't think you were.
I don't remember this at all,
Yeah.
otherwise. Go ahead.
So law enforcement, if you recall, a number of years ago, abortion clinic bombings and such, if law enforcement is tracking a guy that's a person that's a threat, you want to know if they're stalking.
Okay,
a
that's
facility.
fair. That's a fair example. I was thinking about it from the other direction, as I mentioned yesterday.
They suggested this language. They said that.
Alright.
Yeah.
I'm not sure of it. I don't know.
There were also in-hall conversations that informed something, like there's a lot of stuff happening yesterday afternoon as well. So.
There's a lot of stuff happening.
There's a lot happening.
That's an understatement. Okay, thank you. I can deal with it, I guess.
So let's jump down to the last piece here on page 20, the seventh instance of amendment. There's some slight tweaks to the AI Council, AI Data Privacy Advisory Council, add some pieces to the report. So at the very bottom of that page, we have, based on the discussion around what's happening with PRA, including in that report recommendations for creating a clear process for consumers to pursue a private right of action and provide notice. So we talked about what form should that notice take. This is meant to task them with developing recommendations to clarify. And recommendation for improving the scope of the healthcare exemptions, which goes to the big conversation that we've been having this morning, including based on, of course, we have the research on effects on healthcare industry of those health-related data level exemptions. economic analysis of compliance costs, which might pick up some of the discussion that you just had around the area agencies on aging, because you could discover whether or not those compliance costs do in fact have a debilitating effect on those folks. And then what's new here, an analysis of health-related entities excluded from the healthcare exemptions that we've talked about. So if folks haven't made it in at this point, but there are valuable healthcare industry pieces that are not being picked up by the exemptions, trying to discover whether you are protecting the industry that you do want to protect. So that's the last piece of this report. And that's, I think, all of the changes in this proposed amendment. Happy to talk about,
So,
answer questions.
so Senator, go ahead, ask your question, then I have a comment.
Yeah, all I was gonna say is it would be nice to know what the costs of compliance are, because they're being claimed as these debilitating effects, and I just have like absolutely no idea what that is. So anyway,
What are the economic implications?
yeah,
No, but
it would be nice, it would just be nice to.
Is there anybody in the room that can address that? Any advocates?
I probably can when I speak.
Okay, let's do that. I want to, I would like for you, I think, to talk a little bit, because we went through it yesterday and it's here in the bill, which what we have for private right of action related to healthcare facilities, and how extensive is the PRA that is included in this proposal of amendment.
Sure. So this is tied to the exemptions pieces that we just talked about, given that you're granting entity level exemptions for those covered entities, hybrid entities to the extent of their healthcare components, and business associates. Folks who are meeting those HIPAA definitions don't have to worry about the private right of action. They're safe under this. The claim that they can make, that anyone can make, is that someone can try to sue and say that exemption is not available to you, but that's presumably a relatively simple solve, and someone who is a HIPAA entity, it's not going to be hard for them to demonstrate that they are a HIPAA entity. So I don't expect that to be, this is kind of talking about the specter of the bad faith litigant, and we've obviously had that conversation, so I won't restate it. But if people have the safe exemptions, and I think we've produced the clearest version yet with the least required analysis today, I think we're in a happier place for them. So I will scroll up to the private right of action and say that for those folks, this should not be much of a concern. But what does the private right of action?
Page,
We are on page 17. This is the fifth instance of amendment, and the real relevant, I just pulled the 17, but the real relevant text is contained on 18, on line 13. Oh, wait. So what does the PRA do? A consumer who is harmed by a violation of subdivision 2419B2, that's your processing of sensitive data without consumer consent. And again, sensitive data includes a whole host of health related pieces, consumer health data, biometric data, genetic data, the like. So that's why this is called out. So a consumer who is harmed by a violation of that subdivision or section 2426, which is the specific consumer health data section, so that contains your prohibition on geofencing, may bring an action against that controller, processor, consumer health data controller for the alleged violation if, and they have to take this process, the consumer notifies the controller, processor, or consumer of the violation, and that entity fails to cure the violation within 60 days, or no cure is possible. And we talked about that concept yesterday. What can the consumer seek? They can seek the greater $1,000 for actual damages. So this contemplates non-economic kinds of harms like reputational injury, injunctive relief. They can stop whatever is happening from happening, punitive damages in case of an intentional violation, so extra damages, and reasonable costs and attorney's fees. And as we've talked about, this private right of action would be the exclusive private right of action available under the Act because it doesn't pull in the underlying consumer fraud protection. PRA, there's no question as to whether or not the PRA can be offered for other sections of the bill. This is crafted just to target those particular two sections.
so it's healthcare.
It is healthcare. I mean, it is worth saying sensitive data does include things like financial information. So sensitive data isn't just health data. And so I do think it's fair to say that this is a concern of this committee, but it's also worth noting that in having a private right of action that includes violations of 2419 B2, you are addressing violations of other kinds of data that aren't consumer health data. But I know that that's been the topic every time I've come in here, has been trying to find ways to prevent processing of that data without consent.
Well, financial information is a key part of healthcare as well.
Sure.
All right, questions for John? This is good. I know we have Senator Brown is here from Economic Development. What is your time like, Senator?
I mean, my committee has a minimal quorum and
Okay,
I
so
should really get
here's
that.
what, and so Kiki, can you contact Kristen and
You're just gonna make that one change.
Mark Hughes and let them
What's
know
their-
they're gonna be about,
The AAA
7
is taking
minutes.
them out.
Oh, yes,
we'll
and
put you up
yes.
here for about 7 minutes.
So what are
Does
we
that
doing
work?
now?
I'll do my best.
Yeah,
to take them out.
okay.
It'll be this or the floor, so.
Taking them out,
Um,
taking.
And
the
then
exemption
we'll,
out?
because I can bring this into your committee if you'd like as well, or, John.
Right, I would love
Yeah,
for the committee to hear
okay.
what I have to say.
It'll probably be
Great
me
being
speaking
sarcastic.
through John.
Okay.
John not speaking through me.
You're so dry that when you're sarcastic.
So we'll let Senator Rom take place, and then we'll bring you back in about 20 minutes. So please stay.
Okay, yep, I can.
Okay, good morning.
Good morning.
Committee, we're going back and forth to each other's committees on various things, and we just went through your cannabis,
Okay.
medical marijuana
And
bill.
I have a slight recommendation that I haven't shared
Okay,
with the committee yet, but it's pretty
Okay.
simple. It's
Well,
adding
so you're
somebody to the
coming in.
working group.
okay, great. So we appreciate that, so thank you for that.
Everybody wants to be on working group.
Well, this is the Cannabis Retailers Association of Vermont, so I think they do have an interest in it.
So
Um,
we're in Canvas now.
no, I'm sorry, I
No,
was just
no,
saying we're
no,
switching places today and we appreciate your.
No, we're still on
Yeah,
121. Our proposed amendment, and Senator Brown's committee has been working on this bill, all the sections, and has left healthcare to us, which is terrific, and we appreciate that.
for the record, Senator Kate Strong Hinsdale, Chair of Economic Development. I think we all wish we had more time with this bill. So given our limited time frame from crossover onward in our committee, I did a lot of my own extensive research and have talked to experts who are on all sides of this issue. And tried to use that to the best of my ability to inform what you received as voted out of our committee. I think also worth noting is our committee started the year with the Kids Code and looking at sensitive data as it relates to minors. And in that regard, presented a stronger proposal to the House in terms of not buying or selling children's data at all. So we take very seriously data privacy. It's really important to us to get it right. I will note that that bill was specifically directed at big tech. We talked to our local businesses. We, really tried to understand the intricacies of what they do, the control they have, the control they don't have. And people look at the PRA, people have talked about it in the press as though this is you're either on the side of big tech or not. Our bill related to kids' data privacy very much opposes big tech, the largest companies in Silicon Valley, who we believe are exploiting and addicting our children to social media. Data privacy is a huge and complex world that we've tried to delve into. And in many cases, most of us rely on the same tools used to maintain our privacy that, we are now potentially creating liability around. I heard, and I don't want to mischaracterize anything, but I heard there was a lot of conversation about menstrual apps, privacy around that. I completely agree. I am using one right now. Every Friday, my menstrual app tells me what week of pregnancy I'm in. I'm at 22 weeks right now. Certainly have a deep interest in keeping that information private. I just want to acknowledge that if you put a PRA, and I used to be on the board of Planned Parenthood in Northern New England, no one faces litigation threats more than Planned Parenthood. If you put a a threat of litigation on some of that medical data and those apps, I believe that you would be creating liability for an organization like Planned Parenthood or the apps themselves that do that tracking for the benefit of people who get pregnant. And the exemption here is for law enforcement, which in many states or trying to cross state borders are the entities that are trying to get that information. So if a healthcare organization was required to turn that information over, you would be able to sue them and not the law enforcement agency or government agency asking to get that information. And that would concern me a lot. I do want to address a couple things I think were said yesterday. That Clearview AI has an ongoing case vis-a-vis the Attorney General's office. I believe it's a matter of public record that Judge Helen Tour dismissed that case in the relevant county that it was brought. And she was in fact disappointed. I believe she wrote something to that effect in her communication to the AG's office because of a failure of the office to appear in that case. So the AG can bring that case in another county, but to my knowledge, there's nothing ongoing right now vis-a-vis Clearview and the state. We heard in our committee that the Attorney General believes she has the capacity to enforce and to educate, which was really critical to us. We are creating a whole new area of law that people must comply with. We've heard estimates that it costs about $50,000 per entity in California to comply with that law. We also have the Vermont Law and Graduate School Small Business Clinic in, and they believe that they estimate it would cost about $150,000 just to distribute contracts to organizations that work with small businesses. We didn't have the money for that, which is another reason that we wanted to look in more detail at the private right of action before we included anything like that. I understand that the AG's office came here and said they don't have the capacity to enforce, and that's why they need the private right of action. But that makes me also concerned about their capacity to issue guidance and educate businesses on such a vast and complex law before people would be exposed to a private right of action. So we are really looking, I even mentioned this to Senate Appropriations, we really need the money to help educate businesses before we hang the threat of private right of action over them. Because if that threat is hanging out there, businesses are still going to want to comply. They're still going to be looking at trolls around the country who are saying, you know, this takes effect in a couple of years, and we should be looking at who's complying and who's not in Vermont. That to me brings me to this large issue with the PRA, that it's considered the boogeyman in some circles, or it's considered the holy grail of bringing down big tech in other circles. It is neither. It's a legal tool that we have seen used appropriately or inappropriately in the scope of litigation against businesses, healthcare organizations, et cetera. And that brings me to my last point, which is about Illinois. It was really important to me to look into the only state that has a long-term PRA. Washington's is new. We don't have very good data from Washington's. I hope they have a better experience focusing on medical data, but biometric data in Illinois has been a bit of a disaster for the last decade or more. And I've printed out 3 separate articles. Some of them I read before with news organizations or other organizations, but I tried to stay consistent and just print 3 from legal organizations that are trying to better understand what's happening. In Illinois, there have been about 200 lawsuits related to biometric data, and they have caused excessive costs, I would say, for nursing homes, school districts, manufacturing facilities, because biometric data has been around your ID or your fingerprint. So one of those is a recent case where some of the hospitals in Illinois were using fingerprinting to know who was in a hospital getting pharmaceuticals and administering them to patients. So they had a record of, you know, who was going into the pharmaceutical supply area. Healthcare workers, with the help of lawyers, brought a case against the hospital. It had extreme costs for the hospital. And the upshot of the Supreme Court case was healthcare workers being exempt from the Biometric Information Privacy Act, BIPA, in Illinois. Illinois is now this year voting on removing the ability to do class action lawsuits in their Biometric Data Privacy Act. So I think we have a lot to learn about this. We would be the first state to put out a private right of action beyond biometric data on sensitive information. I would deeply oppose anything beyond the scope of healthcare data, which is a majority of what is regulated or would be regulated under this section. And I have heard from Senate Judiciary and Senate Appropriations that they would also want to take this up because this could deeply affect the appropriations of the state to healthcare organizations and other nonprofits. And private right of action is generally the jurisdiction of Senate Judiciary. So those are some of my comments. I really, after going around the bend on this, deeply advise us not to take this step until we have the Agency of Digital Services and the AG better understand what the appropriate private right of action is and not hang this threat out over businesses, which is our jurisdiction, because it's very costly for them to comply. Even if we didn't do the private right of action, we now would have the strongest data privacy legislation in the country, and they are going to have to figure out compliance proactively. And we want to be a partner in doing that before we tell them there's a huge threat of exposure to liability hanging out there.
Terrific, thank you. Questions?
Yeah, just curiosity. I'm wondering, so consumers need protection from via some vehicle, whether it's the Attorney General's office or it's private right of action. I'm wondering if the Attorney General's office feels that they can handle the load, which might be created from this legislation.
One thing I would say to that point is we've had data broker legislation on our books for 5 years or more. Data brokers, that was like, a big pioneering thing we did to look at people who buy and sell data as a majority of their revenue. And we, said that you have to register with the state, you have to comply, et cetera. We do not have a private right of action in that section. The same language from that section we put in the new section on data controllers and processors, which gives sole authority to the Attorney General. The Secretary of State's office came into our committee. They did not come into the House. They opposed the section of the bill that would require more of them to track data brokers and scour for people who want to have their data removed from everywhere, from every data broker, because that would cost them $8 million. Government is not ready to comply with this, though they would not fall under a private right of action or really the tenets of the bill. But they also said that in the time they've had the data broker section, they've had about 3 inquiries about the purchase and sale of their data. So they haven't really seen, a large need for enforcement. When the Attorney General came to our committee, she talked about data breaches. Data breaches are essentially a separate matter, and this exempts most entities that have experienced those types of data breaches regardless. So I'm not sure how this bill would solve any of those problems.
So I have a question about the exemptions that are currently in the bill. Did those exemptions, did you put the exemptions in for the banks, insurance companies?
That was the House.
The House did that, and so I'm trying to understand your concern has been big tech, and I think that's a concern around this table as well.
Illinois did not bring down big tech.
But so big tech, right, and I'm thinking about most of the banks that we deal with are big banks. No. So now, what's the distinction between the big banks that we have in our state and big tech? This is a rhetorical question. Or what is the difference between the big insurance companies that are national and global and big tech? So that is a question that is not in our jurisdiction, but is in yours. And I'm just asking that rhetorical question just to float it out.
And that's why we should study it.
Well, but here's the other problem that I see with studying these things. It's great, but once you put an exemption in place, or you say no PRA, the difficulty is coming back and saying, okay, now we're going to impose this regulation on you. And we've seen it time and time and time again, where it's harder to eliminate it than it is to start it in the first place. So that is another rhetorical. Having said that, I do hear what you're saying about PRA, and I do think there are some significant concerns for businesses. But right now the bill is doesn't allow for anything or any public. Anyway, and one last thing. So this all takes effect in 25. that we can put a date out and we have a report coming back.
Yeah,
So it's probably easier to take it off than it is to put it on in a short period of time. And next year is 2025. And so we have that little window of time where we could modify what we're talking about here. So I'm gonna leave it there.
if I may make one last comment.
Yes, you may.
Because I don't think that's a rhetorical question. I really encourage you to look at Illinois. They unleashed a biometric information privacy act over a decade ago.
Yes.
There have been multiple Supreme Court cases where they have asked the legislature if they would like to have the power to annihilate healthcare organizations, annihilate nonprofits, annihilate some of these entities because each infraction has resulted in a financial violation. And the legislature, probably because they didn't want to take back something they had done, have waited over a decade to address this until it's gotten so bad that the Supreme Court basically publicly said, you are allowing organizations to be annihilated by this FIFA provision. And this year, earlier in April, the legislature took action to change that. We are a very small state compared to Illinois. And the power to annihilate is great. And that's why you see people coming in. I don't know who represents Google. I don't know who represents half of these big tech companies in the legislature. I do know that small businesses are coming to us and say this is going to harm them. And my concern are the people who don't have lobbyists, who aren't here, who have no idea what we're doing and have to comply.
We
And that is
understand.
nonprofits, healthcare organizations,
I
and
understand.
businesses.
We get it. You got it.
Just so you know what you're going to hear on the
So,
floor.
and we do understand the small business piece, and many of our healthcare businesses are extremely small businesses, one person business, so, or two people, so we're just. But we hear what you're saying about PRA, and after we will come back to this, we're gonna take a break, we have another issue to take up. But we will come back to this, and we hear what you're saying about your committee and appropriations and judiciary and everything else, so we, stepping over that line might be something that causes a very long floor debate. So, yeah, we got it. So Senator Gulick, you had your hand up.
I wanted to ask for clarification, that might also be rhetorical, but in the example of the pregnancy app, it seemed as though you were suggesting that the danger there is with law enforcement, accessing information. And I guess my question is, who's to say that a pregnancy app is a benevolent, product? I mean, who's to say that they're benevolent and not nefarious?
I wouldn't characterize any app, any healthcare app as benevolent or nefarious. Senator Lyons and I were on a healthcare task force together where we heard there are private companies now that can take aggregated data and tell us where we shop, what pharmaceuticals we purchase, et cetera. Data, is not neutral in any way. But they, in our state, people rely on these apps. Planned Parenthood is a healthcare nonprofit. The question is who is subject to this and what litigation possibilities might they face? And I'd like to learn a lot more about that. Washington just did this, and Senator Lyons and I went to the White House with Mira to talk about private rights of action in data privacy and what Washington is doing. And I'd love to know more about what they're doing. And the private right of action could be
Right up
very
on the
valuable.
wall. If we had done this with separate bills, we probably would have seen what.
Right. But I think it's,
Right, I just wanted
the question is
clarification.
who would face litigation, and in Illinois, it's been very low hanging fruit. It's been nursing homes and small healthcare organizations.
Okay, I'm gonna have one more question because we have another topic and we've got a really tight
Just-
schedule.
Broadly, can you explain the difference between the Connecticut law and Illinois? Because I've got some constituents that are saying they support the Connecticut law.
We most of the bill is based on the Connecticut law and then strengthens from there in terms of adding the California Delete Act or certain biometric provisions from Illinois or many other states. Many states have mimicked Connecticut. I sat down a few weeks ago with the chair of the committee that wrote the bill in Connecticut, Senator Jim Maroney. He's testified in both of our committees. They don't have a private right of action. They have a very standard framework for who's a controller, who's a processor, and how they're treated. And where we felt there was inconsistency, we went back to the Connecticut language in our bill so that we have interoperability with New England, because a number of New England states have adopted their language as well.
Thank you. That helps.
I've done way too much work on this. I spent way too much time.
That's good. I'm glad you have.
Don't make me do any more.
I do have the 612, and for purposes of my committee, on the 612 proposal amendment, we had a Cannabis Control Board working in consultation with Department of Health, the Medical Society, and other interested parties. The request has been to add the Cannabis Retailers Association of Vermont as one of those on that, and I'm fine with that if you guys are okay with that.
Sure.
So I'm gonna give this to.
Okay, are you still coming in or?
To Michelle. If you want me in, I'll be in.
I mean,
But if Michelle.
I think we're pretty, I've seen the language probably pretty good. Yeah.
Okay,
Okay, thank you for having me.
No, thank you very
Yeah.
much, Senator. It's great. So now, just we're shifting over to something that we talked about quite a bit ago, and Kirsten and Murphy is here, as well as Mark Hughes, who's outside. And we're gonna come back to this.
To 121.
Yes, we are.
Okay, I might have to step out to deal with some governance bills, so, okay, when are we gonna potentially vote on 121?
As soon as we get back to it. So as soon as we complete our work on the Health Equity Advisory Commission. So Kirsten, why don't you come up?
I'd like to get
You wanna get
Hughes
Mark?
if I may.
Yeah, that'd be good.
I will have that, just 5, Mark, 10, okay, thank you.
Reverend Hughes has disappeared and I know that you're running very tight.
So we certainly are.
Yes, I will, he walked off with my slide deck. It's make my life very, very challenging. Not impossible.
No question.
What's that? No pressure, none whatsoever.
Just relax. Do you have shared screen?
I do not, I think he was gonna maybe run the slides for me.
Oh, either way.
Okay.
There you go.
Oh, yeah.
Do you want to sit together? How do you want to do
Yes,
this?
that would be great.
She's not big enough.
Mark. There you go.
Morning, Madam Chair.
Good morning. So we're gonna get your slides up.
Okay.
But in the meantime, why don't you introduce yourselves for the record, and then we know we've heard some of this testimony previously.